First, thanks to Lisa for being here as well. I know she needs to leave, so she'll also have the opportunity to pop in if she needs to on anything that relates to this. But I kind of thought as we were at staff talking about what would be a very, I guess, pertinent and important topic was the aspect of eligibility. And so really what this is, it's a PowerPoint with all different situations that I get calls from related to eligibility, and could be class 1A school, could be class 5A schools, but these would all be situations that I have received calls or I guess encountered even my 26 years as an AD, some of those, you know, that it happened during my time when I was an AD. So hopefully you'll enjoy it. It's pretty informal. One of the things that I'll do on all these is I have situation, I put the situation up first, and then the question at the end is a student eligible, or what's the status of the student on this situation? And so I'll just kind of go ahead and do the first one and then kind of explain the process that we want to do. But again, it's very informal. I'm not sure how many people are on, but again, if you want to interject and ask questions, we can. So I'll go ahead and get started with the first one. And really what I did was I labeled students, just student A, student B, and then school districts or schools, school X and school Y. But I think one thing that would be, to me, real helpful is if you can, in your mind, kind of visualize in your area. I think it's easier sometimes associating a school, a specific school with another school, you know, so like here, student A lives in school X district boundary line. So you can say, okay, student X lives in Center Point, and student A open enrolled into school Y. So open enrolled into Marion after her 7th grade year. Following her 9th grade year, student A wishes to attend school X or Center Point her 10th grade school year. Is she immediately eligible for varsity athletics her 10th grade school year at school X, or does she have a 90 school day in eligibility for varsity sports? So this is the classic case where a student lives in one district, they open enroll into another, and then at some point in their high school wants to come back to the school in which their family lives. And so the question here is, does she have immediate eligibility at the varsity level, or would she have a period of time that she'd have to sit out the 90 school days? So I guess kind of here, just in your mind, say how you think this would be ruled. And then what I do in the next slide is then I'll show you kind of what the ruling would be, and then we can visit about that. Does that make sense?
Yep.
Okay, everybody kind of understand what this first situation was?
Yeah, I would say she's 90 days.
Yep, and then that is what it here is student A would be ineligible from varsity athletics for a period of 90 school days at school X. Although she lives in school X, once she open enrolled into school Y then becomes the district she has her eligibility. So we get a number of calls on that where, you know, the family lived in their district, they open enrolled out maybe as a 4th grader, you know, earlier in their year, and then as a sophomore, junior, they want to go back to the school in which the district they live. So you're exactly right, would be an eligibility for the varsity for 90 school days. Any other questions or comments on that one? Second situation, you know, student A lives in school X boundaries and attends high school at school X. So the student lives in the district in which she attends, and after her 11th grade year, all of her family, including herself, move into a neighboring school Y boundaries. Does she have immediate eligibility in school X or school Y? So this is a case where, you know, she lives in X, they move, the family completely moves into a neighboring district, and I guess the question is, does she have eligibility where she was at, and or does she have eligibility in the school in which they moved to? So kind of think about that. What are your thoughts on that one?
I would say both.
Anybody else?
I say both.
Yeah, and that would be, you're exactly right. Student A could have immediate eligibility in either school X or Y, since the family has a contemporaneous move into school Y. So all the family moved, she would be a resident of school Y and would be immediately eligible if she attended school Y. And then student A could also continue to attend school X, so she could stay there as long as there's not an interruption in her attending school X. So that's that continuation rule, that as long as she continued to go to school there, she would, now she'd have to open enroll back, but that's a formality into school X. Since they now do not live in that district, they have to open enroll back just for the central office work. But since she didn't have an interruption, she would be immediately eligible at all levels. So that one happens quite a bit. A lot of times with upperclassmen, you know, where the family moves and they want to finish out, you know, their senior year at the previous school. Can they do it? Can they not do it? Any other comments on that one? That's a pretty common one. Next one, okay, this is a little, you got twin daughters here. They're both 8th graders. So you can kind of picture, you got twin daughters that are 8th graders and they attend one school. Their family has completed open enrollment and been approved for both students to attend school Y. So beginning their 9th grade school year. Okay, student A, one of the twins, played softball at the school that she attended as an 8th grader. School B didn't play softball that summer. And so the question is, when student A begins classes at school Y, her 9th grade school year, does she have immediate eligibility at the varsity level when she participates in varsity? So you got two different girls, two different little situations. And then student B begins classes. Does she have immediate eligibility at the varsity level? So this comes into a case of when would students be eligible and what causes them to be eligible here. So thoughts, feelings on student A first.
I think student A would be ineligible if she already played varsity contests for her previous school.
Anybody else thoughts?
I would agree with
Typically, as an 8th grader, she's not going to be playing varsity. It could have been a middle school softball team, right?
Yeah, it doesn't have to be just varsity. You're correct.
Yeah.
So she's not playing, the 8th grader's not playing in varsity, she's playing middle school?
Or she's playing JV or whatever. She's just playing at the previous school.
I would, if she played at the high school level, I would say she's got 90 days, but I could be
I
wrong.
think student A is eligible.
Okay, what about student B? This is a girl that didn't play softball.
She's eligible also, I think,
Yeah, she's going to go right away.
at the beginning of their 9th grade year.
B's eligible.
Okay, and this is the one exception about all incoming 9th graders, because the general basis is all incoming 9th graders, and you look at the last comment first here, it said all incoming 9th grade students have immediate varsity eligibility unless they participated in softball or baseball the summer prior to their 9th grade school year at the school the students had previously attended. So it's at any level. If they played middle school softball all summer at the previous school, or JV or varsity, that student would be ineligible for varsity beginning that fall. So that's a decision that I have another situation later that relates to softball a little bit on different options they have. Whereas the student B, you know, their open enrollment must have been accepted, so they were going to start in the fall. So she would be eligible for all varsity levels. So that's the key, is softball and baseball, you know, and a lot of times they'll ask that question as they made the decision they're going to go to a school in the fall, you know, they want to play softball. And that's important is for an AD at that point to give them a little guidance. Okay, understand these are your options. If you play here all summer, this is what it means for eligibility. If you play here, then this is what that means for eligibility. And again, I've got another one a little bit later that gets into a little more specifics on when you can practice, where you can practice, at what point, that type of thing too. So any other questions on the incoming 9th grade? That's kind of that big question of our incoming 9th graders. They open enrolled, you know, in the spring of their 8th grade year. And then are they eligible as 9th graders or not? And this is the one, I guess, exception about softball and baseball.
So
Gary,
go ahead.
sorry, Scott.
No,
Yeah.
go ahead, sorry.
Gary, to clarify though, that only applies to varsity level participation, correct?
Nope, any level. You mean in the fall for eligibility, or
Yes.
playing softball
Yes.
in the summer?
Yes, so I think it's student A that participated at her previous school in softball. She would still be eligible in the fall of her freshman year to play freshman volleyball, just not
Yes.
varsity volleyball, correct?
Yes, that's correct. Yeah, she would
Right.
only not have varsity eligibility. But again,
Thank
for
you.
her playing softball, it could be playing on the 8th grade team, or it could be playing varsity.
Right.
That part isn't as pertinent as where did she play softball. But in terms of in the fall, yeah, she could practice with the varsity, but she just couldn't compete and play against other schools at the varsity level.
Right, thank you.
Anything else on that one?
Just one more point of clarification on that, Gary. So even if that 8th grader played 8th grade softball, they would still be ineligible at the varsity level. I'm talking about student A.
Yeah, so let's say student A, she starts in the early part of May for their junior high practices, and then she plays up till the end of June at the 8th grade team that summer. That establishes that as her eligibility district at that point, because she has a decision to make at that point. Is she going to play softball at her school she attended, or is she not going to?
Okay.
Yep. So it's not just varsity. It's even junior high, or because you established that then as your district. I had that happen to me 15 years ago, and a kid at Johnston when I was there. He was an 8th grader, and he played baseball at Hoover as an 8th grader, and lived in the district, came to Johnston 9th grade. And it was at that point, he couldn't play any level. And they changed that a number of years ago where you could play non-varsity levels. So anything else on that one?
I have a question. Yeah, Gary.
Yeah.
What if your junior high softball program in this situation is not through the school? It's a city rec league. How would that affect if she played 8th grade ball down with the rec team, but not with the school team? Would she be able to then start right away?
Yeah, if she's not part of your sanctioned school-based program, then it wouldn't have any impact. So she could play ASA or whatever she wants with any team or whatever she wants, as an 8th grader. It's if she plays in the school-based program that's under each of your jurisdiction.
Perfect. Thank you.
Anything else on that one? Okay, here's our divorce situation. You got divorced. So student A's parents are divorced. Student A's mom has primary custody of student A. Student A and her mom live in school X boundaries, okay? Student A's father lives in school Y boundaries. Student wants to attend school Y and live with her father. Does student A have immediate varsity eligibility in school Y district? So it's one of those cases where the parents are divorced, they live in different school districts. The mom has the primary custody of the student, and that's where she lives. And then she wants to change her after junior year or whatever, go live with dad for whatever reason. Interestingly, you hear all kinds of stories, but it's not athletic related. It's she just wants to go be with the dad because mom and I are not getting along. So what do you think? Varsity eligibility at the district in which the dad lives or not?
I think she's eligible the first time they move.
I say 90 days.
90 days.
Harley, this speaks to your age because way back when they allowed one move to be to varsity eligible, but that's no longer. Years ago, it was that way. And look at the last note here first, and then we'll go up to it. Please note, at the time that a student's parents become divorced, so let's say they're married and living in the district, and at the point they come divorced, now the parents go and live in different districts. At that time, the student has the choice of which of the two parents and which of the two districts do they want to be in, and they would be immediately eligible there. But once they make that decision, then unless there's a change in their legal custody, then that would be viewed as a transfer there. So without a change in the custody agreement, student A would have a 90 school day ineligibility at school Y from varsity sports.
They do have the option of changing custody, Gary?
They have to go through the legal court system, yes. So
Okay.
that's the second one, is if the parents change the custody agreement, and it's got to go through the legal court system. And a common thing that you see is there's joint custody. A lot of times the parents have joint custody and they're living with the mom. Well, by them going to the dad with that same custody agreement, even though it's joint, they haven't changed the legal custody agreement. So then there'd be an eligibility. But let's say the mom has the custody and they go actually into the legal court system and they get it changed to the dad having the primary legal custody, then that student would have immediate eligibility. But understand that in changes of legal custody, it can have a lot of other implications, some financial, some in terms of ability for the student to see the other parent, et cetera, et cetera. But just to go live with the other parent without a change in legal custody would not grant that student immediate eligibility. And a lot of times what happens is that last little question where, you know, they had a separation, okay? Just because they're separated, that's a little bit, that's a different, that's not a divorce. You know, they can have a legal separation that's through, you know, the legal court system. But unless you have the change in the legal custody, it wouldn't grant the immediate eligibility.
So if they had a legal separation and the courts gave primary custody to one of the parents, would that be the same then?
A legal separation would be viewed in the same of the divorce. And the key thing on that one is, where was the child at beforehand? You know, and let's say this case, they were separated, but the mom lived in one district, the dad in the other, and the daughter was living with the mom. Okay. So in order for her to be eligible with her father, there'd have to be a legal separation where the dad has, if you want to call it, custody of the child in that case. So similar to what the legal custody for a divorce would be. But you can't just sign yourself and agree that the kid's going to go live with dad. It actually has to go through the court system. And this is what I suggested when you have this, is you want to get a copy of the legal custody agreement in advance, and then you want to get one when it's changed. And I mean, there needs to be a change in the custody. I mean, it can't be something like, well, custody is still the same, but we change the amount of money that we're going to give to you. And if you have questions when you get that, you can get that either to the girls or the boys to take a look at, to see if, in our opinion, that there, or your court or your legal, you can get your attorney to take a look at it. But the key is there's got to be a change in the legal custody from one parent to the other parent. Anything else on that one? That one's kind of a common. Unfortunately, that happens too much in of all our situations. Next one here. Student A is a senior, student B is a sophomore. They live with their parents in school X boundaries and attend school X. So everybody, they're going to school there. School A and B's dad has a job transfer and moves into school Y district boundaries in February. Student A and B's mom and student A stay in school X. So the mom and the senior stay in the district that they were attending to finish out the school year. School B moves with her dad and attends school Y. So now the question is, does student A, who's the senior, does she have varsity eligibility at school X? And then the second part of that, student B, does she have varsity eligibility at school Y? So let's look at the senior first. So her family all are living in one district. The dad gets a job. He he moves away to start his job. The mom stays back and lives in that district. Okay, would student A have varsity eligibility? Let's say she's, the dad moved in February. Let's say she plays soccer in the spring.
She's eligible.
Okay, anybody else thoughts? Okay, what about student B?
She's eligible as well.
Geez, if I was a student, I'd want to go to Clarinda back in the days and be eligible then. Actually, student A has varsity eligibility at school X because she's had continuous attendance. As long as there wasn't a break in her attendance, she would be eligible and be able to continue to live there. School B will have student B will have a 90 school day of ineligibility at the varsity level because she has not had a contemporaneous move by her family. And again, it's not just because her dad moved. Obviously, if it's divorced, then you've got a different situation. But the family is moved, so as long as the complete family didn't move, it's not a contemporaneous move, then she would not have immediate varsity eligibility. And we see that happens a lot where you've got the senior and the mom is going to stay back with the one daughter to finish out the year, and then the one younger student is going to go live with the dad to get a fresh start on the school and meet people and all that, which makes a lot of sense, but the question comes in, what are you going to, is eligibility that important for the sophomore moving, or is it not? Because, some cases what happens is the family all moves, and if it's a neighboring, let's say it's a close district, a lot of times you'll see the complete family move into the district, and then student A, she'll drive back to finish out her year. Then you would have that contemporaneous move, then the student be eligible. But if it's a distance, let's say it's 3 hours away, and this happens, that's not an option that they have. Now, again, that's a tough situation, because is it the best for the family, for the younger one to get acclimated at that time of year, or are they better off waiting until the year is over, then the complete family moves over at the same time? And that's what some people make, the decision. They say, you know what, it's important that we have varsity eligibility, so we're gonna all stay at home. Dad's gonna commute, live by himself. Daughter's gonna finish out her year, and then we'll all move as a family, and then the student would be eligible the start of the fall.
They could circumvent that with a separation and legal separation, couldn't they?
I suppose you could go you can go into the court system and legally with that. But again, there's ramifications with that. But
just a thought.
Anything else on that one? I mean, that's a common one that happens with people getting job transfers and one child staying back and one moving. Okay, next one. School A is a junior. She lives in school X with both parents. Student A wishes to go live with her grandmother in school Y for whatever reason and attends school there. Does student A have immediate eligibility at the varsity level at school Y, which is the district in which her grandmother lives?
Eligible. Loretta's being liberal again.
Any other thoughts? Student A would be ineligible for varsity athletics since she and her parents did not have a contemporaneous move into school Y, even though grandmother might have gotten guardianships, right? And a lot of times school districts require, a guardian for signing, papers and getting communication. This would not allow immediate varsity eligibility at school Y. So, there are certain situations, if there's abuse involved or it going through the court system, where they legally might change the, custody rights, where you could have an appeal and some exception to that. But the basic, they're just going to live with grandmother, doesn't grant immediate eligibility. So if there are circumstances that really dictated and made the move, then that would be the case where those are kinds of questions that we would look to see if there's an exception that might apply for that. But the basic rule would be she's not eligible at the varsity level. Anything else on that one? Okay, next one. Student A is a sophomore. She lives with her parents and attends school in School X boundaries. After her 10th grade year, student A goes to Florida to play on a nationally renowned club soccer team and attends school in Florida. Her parents didn't move. After her junior year, she returns to live with her family in School X. Does student A have immediate eligibility at School X? So occasionally, I know I personally, when I was an AD, I had this happen in hockey in the Omaha area. I've also seen it up in the Twin Cities with soccer, where some teams have gone up and played on a kind of a big club team versus playing at their school. So in essence, the family lives in one school district, the School X. The student goes away for the school year, attends school up there, plays on this club, or it goes to Florida, plays on this club team. After a year, finds out, I miss my parents, I miss my friends at my school. This isn't going to make a difference for me getting my Division I scholarship. And so she comes back and lives with her parent at School X. Is she eligible? So think about that one. Student A would have immediate varsity eligibility at School X when she returns to live with her parents. Iowa Code allows students to return to live with their parents and have immediate eligibility in the district in which the parents live. So one of the parts that sometimes you see is where students are allowed to go back and live with their parents if they've gone away. So this would be a case, they believe that it's in the best interest of the kids to live with their parents anyway. So if they go away and then they come back, it's a different matter than parents living in one school district, the student going to school in another one and then coming back. But this is where they would actually go away and then they come back. The key, and our next situation is a little bit different. It's similar to this one, and I'll flip to that here. So the same situation, she lives in School Y district with her parents, but she open enrolled into School X after her 3rd grade year. So the family lives in one district, the student attends school in another district. After her 10th grade, she went up or she went down to Florida and played on that same club soccer team like she did before. After her junior year, she returns to live with her family. Does student A have immediate eligibility at School X, which is the school she was attending before she went to Florida? So you see the little bit difference between this one and the one before. The one before was she lived in the school district in which she attended. This one, her family lives in a different district than where she attends because she open enrolled. So when she comes back from Florida, that's the question you have is, where is she eligible at? What do you think on this one?
I think she's ineligible.
Yep, and the key there is she's eligible in the district in which the parents live. You know, so that's a situation that happened to me as an AD, and I remember that where a kid went away. They had open enrolled earlier, so the kid had gone to school there his whole life. It was a boy, and when he came back, they lived in the Woodward Granger School District, but he attended Johnston. And when he came back, you know, he would have been immediately eligible at Woodward Granger where the family lived. But he attended Johnston, he had to be a transfer, open enroll, and he was ineligible for 90 school days. So, but that's kind of two different situations. If a kid goes away, they're eligible in the district in which the family lives, not necessarily where they'd attended school before they went there. Questions on that one? That one doesn't happen very often, but it is one that has come across the desk. Next one, and this is a case where you've got a public school and a private school, or a non-public school in the same district boundaries. So you can picture, example of West Des Moines Valley and a Dowling would be example in the Des Moines area, or a Regina and a City High, et cetera, et cetera. Student A attends a public high school, School X, and lives in that school district boundaries. Student A transfers to a non-public high school, School Y, which is within the same district boundaries. Or it could be like Fort Dodge and St. Edmunds, same thing. Does a student have immediate eligibility for varsity athletics since student A transferred from a public to a non-public in the same district? Nope. Student A would be a transfer student and have a 90 school day in eligibility. The fact that both the schools are in the same school district doesn't have any bearing on that. And I think that's a misnomer that some people think is if you're in the same boundaries, you can go from public to private or private to public, but it's viewed as a transfer. You've established that school as your eligibility district. It'd be just like transferring to a school outside the district boundary lines. Any other thoughts, questions on that one? This is in our kind of our homeschool guidelines thing. So many of you have homeschool students in your district. Student A and B, so it's a brother and or two sisters. They live in the district boundaries of School X with their complete family. So the complete family and the two daughters live in their district. They're homeschooled students and of the high school age. Student A wishes to participate in athletics at School X. So student A wants to participate in sports in the high school in which the district boundaries in which they live. Student B wishes to participate in athletics at School Y, which is located outside the school boundaries. So it's a neighboring district. Can student A participate in sports at School X? If so, does the student have immediate varsity eligibility? If so, what steps does student A and her family need to complete in order to participate? And then shifting to student B, can student B participate at School Y? And if so, does student B have immediate varsity eligibility? So let's look at the first situation, the student A. The family lives in that district and they homeschool. So let's just say Center Point here. The family lives in the Center Point district, and can they participate in sports at Center Point? What do you think, Scott?
I would say yes.
Okay, and so then would that student have immediate varsity eligibility?
Yes.
And then do you know what steps that student and family need to do to complete in order to participate?
I don't know that I can honestly answer that one.
Yep, does anybody know? There's a Form A that the family would have to participate when they're dual enrolled in athletics only. And it wouldn't even come to your guys' attention. It's a form that's filled out. We have it on our website. It's under documents and forms towards the bottom. And the family just has to fill out that Form A, get it to your central office. And basically it's just a step to grant permission for that student to participate in your sports. So it's a Form A. And again, it typically isn't even touched by the athletic director. It's a district thing. So that was on A. Now B. So let's say that student wants to participate at Vinton-Shellsburg. Can they? And if so, does student AB have immediate varsity eligibility? And I'll flip on that next one on that one. So this is the second part of that one. In order for student B to participate at School Y, they would have to open enroll just like they would if they wanted to attend it for classes. You know, if you want to dual enroll in extracurricular activities, they have to do an open enrollment into that other district. Once they've done that, then they'd have to fill out that Form A, and it would allow them to be able to participate, but they would be ineligible for 90 school days because they'd be viewed as an open enrollment transfer. So it doesn't, the district in which they live, that's where they're granted immediate eligibility. Now, if they wish to go elsewhere, they have the same ability to do that as any other student. It's just they would have to open enroll, and they would be treated like an open enrollment student for academic purposes as well. And that does happen. Sometimes in a rural setting, what I've seen a lot of times is, they live in the country. Their district is a big district. They live on the outskirts of the district in which they live. It's 40-minute drive to go to the school. The neighboring district, it's 10 minutes away. So they open enroll into that for their student to participate at that school. But they'd initially have an eligibility for the 90 school days from varsity. They could still play non-varsity, right away. Questions on that one? That's kind of a homeschool situation that happens. Okay, this is the one with our, I guess, our virtual schools. Student A and her family live within the boundaries of school X. So a student could live in any of your school districts. They're enrolled in one of the virtual schools, and right now there's 3 virtual schools approved by the state. Connections Academy, which is in Anita, Cam and Anita, Clayton Ridge up in Northeast Iowa, and Des Moines Virtual Schools. This is the first year Des Moines Virtual Schools has been in existence. And so in essence, the student is doing the distance learning. They're a student in that district, basically. That's a school district, these 3 here. And the question is, student A wishes to participate in athletics. Where is student A allowed to participate? So you can pick, let's just say they do virtual learning with Connections Academy out of kind of Southwest Iowa. And they live in, I'll just say Grinnell. They live in Grinnell. Where can they participate? If so, does the student A have immediate eligibility?
Their home school district, isn't it?
I'll flip to the next. 2 options. One of them is the school district in which you live. And that's a change. It used to be the only location that student could participate was a district in which your distance learning resided in. But I think it was a year ago or 2 years ago, they changed it to allow that student to have immediate eligibility in the district in which you live. And I think you have to insure them up to 2 activities, and then anything beyond that, you charge them. Has anybody here had that happen to them? Have they had a student that's in one of these distance learning in your district? Because I know we've had that in a number of schools where they live in, I know in Ames had one, Judge had one. They lived in Ames, was a student in one of these virtual academies, and the question was, can they participate in Ames in unlimited activities? Well, you have to basically allow them at the first 2, and then you can charge them beyond that. But they also could be able to participate in the district. So, and this is one with Des Moines Virtual Schools. Let's say they live in Norwalk, and they want to participate in Des Moines Virtual Schools. Where are they eligible to participate? Well, they could participate in Norwalk, or they can participate in Des Moines, and it's up to Des Moines to determine which of the high schools that student would participate in. And a lot of times what they've done is the one that's located closest to where that student resides in their district. So that's kind of an interesting new twist that has happened this year with Des Moines Virtual Schools. This is the first year that they've had that. And so it's obviously that's a big school district. Cam and Clayton Ridge are small, so it's a different
Gary,
situation.
question.
Yeah.
Am I hearing you correct that you define those 3 virtual schools as school districts in and of themselves?
They're actually open enroll into that school district. Yes. Mm-hmm. It's actually a school. It's viewed as a school district by the state.
Oh, we darned.
But they're the only 3 that are accepted by the Department of Education. And up until this year, there was only 2. The Connection Academy and down in Cam or Anita, and then Clayton Ridge. But Des Moines Virtual added it, and I think you're going to see that expanding. I think I've heard a number of schools that are looking at potentially developing a distance learning program as part of their school district.
And they meet all the criteria as defined as a school district.
Yep, exactly.
Huh.
Okay, next one here. This one happened a lot last year. And so this really came into play last year. If you can remember last year, the weather, the snow days, that type of thing. So student A is a sophomore and her family live within school X district boundaries. Student A has transferred to a non-public school, school Y early in January. It also could have been a public school. So this did happen with a transfer to a non-public, but it could have been a public. So in early January, they transferred. At the time of the transfer, assume the 90 school days of ineligibility would end prior to the end of the school year at Y. So at the time the student transferred, early January, the 90 days would have been in May before the school year was out. Due to snow days, school Y does not require the makeup of the missed snow days. So they're on the hours for academic purposes. They added a few hours to their school day, but they didn't make up the missed days. Due to this, student A does not attend school Y for 90 school days. So let's say it ended up at 88. That student attended that school for 88 school days then, when you count it. Is student A eligible at school Y for softball at the varsity level since the snow days were not made up and the student A didn't attend school Y for 90 school days? What do you think on this? You're exactly right. Student A would not be eligible at school Y at the varsity level for softball due to the fact that the student did not attend school Y for a period of 90 consecutive days. And we seek guidance from the Department of Ed, and this was actually an appeal situation that we had. And what the Department of Education said, 90 school days is 90 school days for athletic eligibility. Athletic and academic can be done in a different manner. I mean, many schools academically go by hours, but for athletic eligibility, it's based on days. And so, in some ways they had planned on in advance, but in essence, that student was ineligible from varsity for softball. Which again, when you look at it, they would have had 90 days, but they didn't have 90 days. So that's where a good lesson is whenever you do have a transfer and you're talking about when 90 school days, it's very important to let them know that based upon our current calendar and our current schedule, this is when your daughter or your son would have varsity eligibility. And then I would always tell them, but also we could have snow days, and remember, snow days don't count for those unless you make them up. Then obviously you count that day. So that's a little thing. 90 days is 90 days. Now you might ask, okay, what impact does that have this year? This year probably is we're going to be able to, we're getting some guidance from the Department of Ed on how 90 days and transfer and everything's going to have with how this spring has been. So we'll come out with some things that will be clear on how you're going to be able to handle that. But based on this situation, it's important to remember, if you're on hours, it's not so many hours, it's 90 school days. Anything else on that one? Here's kind of back to that 8th grade when I was talking about softball. Student A is an 8th grade student living with their family within school X district. Student A is weighing different options for school attendance than a 9th grader. So she's trying to figure out, what does she want to do? Student A is interested in playing softball as an 8th grader. So she wants to play softball. What are the options for her? And that's where I talked about, the one chose to play at the school she was attending, and then the implications. If student A wishes to continue to attending school X, so let's just say she's trying to determine what she's going to do, and she wants to continue to attend the school in which she was at then she can participate once softball practices begin. So, she's an 8th grader. She's going to attend the same school she's attending now. As a 9th grader, she can begin practice right away, as happens majority of the time. The other part is a student A has completed open enrollment papers with approval to attend school Y as a 9th grader. So this is where she's currently attending one school. She's going to go to another as a 9th grader. Student A would not be able to begin softball practice at school Y until student A has finished school at school X. So in other words, and again, let's say she is currently attending Fort Dodge as an 8th grader, and she's going to be going to Humboldt as a 9th grader. She could not begin practicing at Humboldt until she finished her classes at Fort Dodge Junior High. So even though she's going to be going to them in the fall, she can't begin practice. You can't be practicing and being a student in 2 different schools at the same time. She could not practice at Humboldt until she, per se, graduated from Fort Dodge Junior High. And we get a number of calls that ask, when can that student begin practicing at the school she's going to be attending in the fall? Well, it's not until she finishes her eighth grade year at the school. Now, she could practice initially at Fort Dodge Junior High until school ends, and then once she graduates from there, go to Humboldt and be able to participate and be fine for immediate eligibility. But once it gets beyond the school ending, she's got to make that decision. Am I going to go or am I going to stay?
Gary, in your scenario, what if she transferred in like 1st of May, did open enroll papers and got through the school board that she could transfer? Could she start practicing right away?
Is she an 8th grader?
8th grader. 8th grader and moved from Fort Dodge, like your scenario, transferred to Humboldt, and they accepted her to open enroll to start school in May.
Yep, she's a student. She has not yet become the 9th grade, so she's a student at Humboldt. She could practice because she's a student there immediately and have immediate varsity eligibility. But if she's gonna, if she wants to play softball, let's say she wants to play softball at Humboldt, she can't practice with Humboldt until she's graduated, done with Fort Dodge. And that happens a number of times where they know they're going to open enroll and they're trying to decide what can I do regarding softball. And and again, some schools might say, well, if you're not going to play softball with us the rest of the summer, we're not going to want to have you practice as an 8th grader. But others might say, you're still a student here. We're going to treat you as all of our other students as long as school's going in session. And once school's in session, then they go elsewhere. So that becomes a kind of a local decision on how you want to handle that student. But in terms of practicing at the new school, she can't do that till she graduates.
How about a scenario where the kid had done open enroll papers, like you said in that scenario, for the next school? We let them practice at ours, but during that time, they really enjoy it and decide, I'm not going to open enroll to Humboldt, and rescind that open enrollment, come back to Fort Dodge.
Yep, she can do that, and she's not had a
never step
break,
foot in.
Never had a break in there. She would be immediately eligible at all levels. Yep, and that happens because open enrollment are year to year, and all you do is you descend your open enrollment, so you don't have to do any open enrollment papers because you're just descending your initial one. But the key is where did you play softball at through the summer, which would be the eligibility part. Next situation, and again, this one, as I read, it's a little confusing, so I'm going to try to reword it a little bit. But a student went out of state, and she had some issues, not going to school things, but she earned credits for 3 years, 6 semesters, but she dropped out one of those years. And so she kind of was, she only attended 3 years. She attended school for 6 semesters, but she was out of school in between that for a year. Does everybody kind of understand what had happened? It's kind of one of those. She then returned to X after missing 1 year. Following her 3rd year of attending X, she and her family moved to another district. Student A wants to participate in athletics at Y. Is she allowed to participate at Y? If so, does she have immediate eligibility at varsity level? And I'll just tell you, this is the 8 semester rule. If you're wondering about what this is, and I'll kind of flip to the next part because it explains it. Student A would not be allowed to participate in athletics at school Y. Once a student begins school as a 9th grader, so all of you, when you look at their transcripts, at some point students are going to begin 9th grade. Now, if they went to 8th grade 2 years or whatever, that doesn't have any impact. Once they begin as a 9th grader, that starts the 8 semester clock, whether they go to school or don't go to school. And once they've gone to school, or excuse me, once 8 semesters after that have occurred, they're done with their eligibility, whether they attended school or not. You don't get a red shirt year, if you want to call it that. And so in this case, because she'd already gone by the 8 semesters, she wouldn't be allowed to participate, even though it was her senior year at another school. Now, this last little thing is, in certain situation in which there's an accident, severe illness, or other catastrophic situation that has caused a student to not attend school for a period of time, they can appeal that 8 semester rule to the executive director. But again, it's not where they were struggling and they dropped out. I mean, probably the ones we've had is if they were in a serious car accident and they were not able to attend school for a year and then they came back, that would be an example of something that was appealed. Or they had a very bad illness and they missed the whole year. That's the type of cases they have. Mental health, the student kind of drops out, struggling. Those have not entered into that variation from the 8 semester rule. So any questions? I mean, it's just important to note, you find out when they first enrolled as a freshman wherever, and then they're allowed the next 8 semesters to participate, whether they did or didn't.
They could practice, they just couldn't compete at the varsity level. Is that right?
That becomes a local decision on whether you're going to allow them to even participate at that, because they can't compete against other schools. We did have a situation where that question was asked, and what we basically said, that becomes a local decision, because, and some of it's insurance wise. And what are you now? Are they, okay, if they're a student there, then they might be covered. What if they're participating in sports and they get hurt? Is you may want to check with your legal on whether you're going to want to have that student even practice with the others regarding that. But in terms of actual competition, you're right, they can't. But that becomes a local on how you want to handle it. I personally probably would try to stay away from that just a little bit. But again, if they're your student, that could be a decision you have to make there on that.
Right.
Anything else on that one? Here's the one that's a little bit with the academic scholarship rule part here. Student A is a junior. In the fall, she's enrolled in an equivalent of 3 full credit courses her first semester. So she's enrolled in 3 full credit courses. She didn't participate in any sports first semester junior year. So she's enrolled in 3 full credit courses, but not participating in sports. She passed all those classes first semester. Second semester, she's planning on participating in track and field. Second semester, junior year, she's enrolled in equivalent of 5 full credit courses, so full schedule. Is student A academically eligible for the beginning of track and field season, or does she have a 30-day ineligibility period? Let's talk about this one. What are some thoughts you have on that?
I think she's eligible. She's a full-time student at the time that she's going out for the sport. The fact that she wasn't full-time before isn't held against her now. And I could be wrong, but that's how I would interpret it.
Rosie, his wisdom is amazing. I appreciate that, Rosie, because that's exactly right. She would be academically eligible for track and field. The semester in which you participate in sports, you must be enrolled in at least an equivalent of 4 credit courses. Even though she only enrolled in an equivalent of 3 first semester, this doesn't impact participation since she passed all of her classes first semester. Now, if she would have enrolled in 3 3 courses first semester and failed one of them, she'd be subject to the scholarship rule in the 30 days. But it, and that's one I think a lot of people have always thought previous semester you even need to be in 4 full credit courses. But how I know both the boys and the girls have interpreted this and enforced that is you just have to be enrolled in an equivalent of 4 at the semester in which your activity in which you're participating. But you still have to pass all your courses. So, I mean, if you're going to allow a student to take 2 or 3 courses and be considered a student, that's your choice. That's local choice on what you're going to deem as considered one of your students there. Anything else on that one? That's kind of the basic one scholarship part. I have another one later on that relates to scholarship rule.
Remember, there's more lawyers per capita in West Des Moines than any other city in Iowa, so I have to be up on this stuff.
You probably have handled a couple of those before too. Okay, this is one, and this is more local, but I'm giving my own thoughts and feelings on this one a little bit too. Student A received an incomplete at the end of first semester in one of her classes. Is she eligible to participate during the period of time in which she has an incomplete? Okay, and a lot of us have that happen where they're in basketball or wrestling or bowling or something, swimming in the winter, and they have an incomplete for whatever reason. It could have been sick at the time they did the final. Whatever reason it could be. And the question is she eligible to participate during that time in which the incomplete is? So grades came out on Friday. She got an incomplete. You got a basketball game the next Tuesday. She doesn't have that class completed yet. Is she eligible or not eligible?
I would say she's not eligible.
For what reason?
She didn't complete the class yet.
Okay. Here's my response.
I'd say she is eligible. You got 10 days to complete that course, 10 school days, if it's marked incomplete. So it's not necessarily an F. So she gets to compete for those 10 days, but at the end of those 10 days, decision has to be made one way or the other.
Okay, here, this is kind of a long one here. So
good job, Scott.
Technically, student A is not eligible until she receives a passing grade in the course. During the time frame in which the student has an incomplete, whether student A participates in a competition depends on the following. And I think, as you know, sometimes students, you could have a straight A student that has an incomplete for whatever reason, or you could have that borderline DF student. And what I said is, if student A received an incomplete, which is the difference between an A and a B, you generally would be safe in having the student A compete during that period of time. If student A received an incomplete, but the incomplete is the difference between passing and receiving an F, I just said I would recommend not having student A participate in the competition. The reason being, if the student played while having an incomplete grade and then received an F on her transcript, student A would be ineligible to play and consequently would result in a forfeiture for playing an ineligible player. So having an incomplete during that time doesn't guarantee eligibility during that period of time, because the grade that student received on the transcript is what determines what that is. So in other words, if you're comfortable that student is going to pass, I mean, it's not a question of whether they're going to pass or not and be ineligible. You can make that call. That's how you want to handle it. That should be some discussion you have. But the key is, what grade do they end up for that particular time during that incomplete?
Hey, Gary, I got a quick question. So when schools move into standard reference grading, I've had kids that aren't passing the class, but have a B, actually have a B for a grade. But since they didn't pass one of the criteria within the class, they haven't been given a passing grade. Has there been any discussion about how they're going to deal with that?
Yeah, I remember even a couple of years ago when I was an AD yet, that was, how are you going to handle that part of it there? Because, we work with a grade,
Right.
what you're talking about is a different, it's achieving whatever skills that are required to be able to advance on. Somehow you have to determine if they're passing or not passing at that time. If you're comfortable that they're going to, that becomes, how do you want to handle that? Because, different districts have different, like some only allow an incomplete for like 5 days. Some allow it for 10. Some doesn't have a number of days that they have incompletes. And so that becomes a local on how you want to handle that. My little part here is technically they're not eligible until they've received a passing grade, but depending on your reason for the incomplete, you might have comfort in knowing that it's just a difference between an A and a B. They missed because they were sick on the day of the final, and we couldn't get it coordinated to get another test, but they're going to have it finished by the end of this week. Then you probably feel comfortable with playing that student on Tuesday. But there's a difference between passing and not passing. You got to be real careful, because you don't want to have somebody who failed a class then playing a game during that time, because then during that incomplete time, they would be considered ineligible.
Gotcha. All right. Thank you.
That's
Hey,
a good
next one
question.
here.
That's a good question, Scott. That's coming up a lot. It really is. With
Yeah, I
the
know.
individual teachers. That's a good question.
We've run into that a few times, and we just have not let them play, which is, I don't know, I struggled with that, but.
That's a conversation I think, Scott, you need to continue to have, and we probably, need to also have more discussion on that. I know a couple of years ago, Ryan Wise, when he was Department of Ed and he was on the boys board, he had kind of brought in a person we talked about, grading that way, because it's a different world, because it's not how we're used to A's, B's, C's, D's, F's. It's, you have to accomplish this, and once you've accomplished, you move on. If you don't accomplish it, you kind of continue until you accomplish it. And so what are you going to do during that interim time when all other grades are due and you don't know? Here's one with, and again, this is a combination scholarship rule and good conduct. And as you know, good conduct policies, that's local decision. So all of you probably have, I can remember a couple years ago, revising the policy and gathering policies from 20 different schools, and you have 20 different policies. So I do know that how good conduct policies are handled vary from district to district. Here's a situation that can happen. It has happened. It had happened to me before. Student A failed a class first semester of her sophomore year. The only school activity in which she participates is tennis. On February 20th, she was cited locally for a violation of the good conduct policy. Okay, so you have student failed a class first semester. Next activity she's going to participate in is tennis. How are you going to handle the scholarship rule? How are you going to handle the good conduct policy? So that's one. Next one, a student B failed a class first semester of her sophomore year. The only school activity in which she participates in tennis. So that part of it's all the same. On November 10th, first semester, she was cited locally for a violation of the good conduct policy. Okay, so the two differences here is one of them, she had the violation before this first semester ended, in which she failed, and the other one, she had the good conduct violation after the first semester grades were posted. When will she be eligible to participate in both those situations? I think this is a great one to have conversation on, because this isn't really an IGHSAU. The only part we rule on is the scholarship. But I think as an AD, this is a situation you can come across. If you haven't, you will. And how are you going to be able to handle it? Because you're going to have to be able to respond. How about the first one, where she failed first semester and then a month later she got a good conduct violation, but her sport she participates in is tennis. So you got to know how to enforce the scholarship rule, and you got to know how to enforce the good conduct. What are you going to do on that one? Has anybody had that happen before?
Sure, I have. I mean, we don't double whammy them. We depends on what our good conduct code, the number of if it's a first violation, she misses 10%. Thank you. She misses 10% or 20% of her season. If that 20% is covered within the 30 days, then we don't double whammy them. So it's
So you would treat the two exactly the same. If the violation occurred before the student failed, the same as the violation that occurred after the grade was there and she knew she had 30 days of ineligibility because of the scholarship rule.
yeah, they have to do other things besides just miss games. They have to go to a treatment facility and they have to prove they've met with the counselor and done things to make sure that they don't have a drinking or a drug problem. If it's related to those if it's related to something else, it wouldn't be. But no, we don't double whammy them here. We don't make them sit the 30 days and then sit 4 more games after that. We don't do that here.
Okay, here's my little thoughts on this one. And again, this is the only thing from the girls' union is the 30 scholarship days. So I said local policy will dictate how the violation of the good conduct policy will be handled. The enforcement of the scholarship will be handled the same in both cases. 30 calendar days from day one of the ineligibility period. So we know that's going to be, from day one is the first day one, you've got 30 days of the scholarship. Here's a couple of suggestions. And again, it's a local decision, but here is, I guess, through the years and some things I have recognized is, to me, a key is, when does that violation of the good conduct occur? Student A, if you remember, since a violation of the good conduct policy occurred after the failure of a first semester class, apply the good conduct violation after the student has served the 30 days. Here's an example. The student knows she's going to sit 30 days. So if you apply that within the 30 days, it basically gives them a wide open ability to do whatever they want during that period of time. And again, that's fine. That's your local thing. But to me, that's different than student B, who had the violation in November. I don't think they're going to go intentionally fail a class because well, I'm already going to be serving my good conduct, so I'm going to fail a class. I mean, that, to me, maybe they're thinking that way, but to me,
they might fail 4 classes.
Yeah.
Because the scholarship rule, if you remember, I agree with everything. I do kind of like what you're saying, Gary, but one thing that's always bothered me about the scholarship rule is, back when I first started being an AD, we had maybe 1 kid or 2 ever fail because you missed the entire semester if you had an F in our local policy. Then the federal policy took over, the state adapted, where it's 30 days, and all of a sudden we started having all kinds of Fs because they only have to sit 30 days. So we'd have, I don't know if it's because of that rule, but it just seems like we deal with a lot more Fs than we ever used to.
Well, we're gonna get a little bit later on a thing with our new change as of July 1. I'll bring you up a situation there, but
I like your date. I like the fact that I never thought about it that way. Now it's a free pass to go get a code violation because you're gonna have it covered within your academic violation. I wrote a note down about that. That's a good idea.
So if you look farther, what basically it says is, since a violation occurred prior to the failure of first semester class, serve the 30 calendar days for the scholarship rule. So you got 30 days, and any consequences that would extend beyond the 30 calendar days can then be added on the calendar days. So let's say whatever, if you're on a percent or a number of weeks or whatever it is, if it does go beyond the 30 calendar days, then they might have to sit 1 or 2, whatever that would be, or maybe they served it within the 30. But again, that's local policy on how you handle it. The part just from the girls' union is the 30 days has to be served regardless of whether they have a good conduct or not. So that's kind of the basis of that. It's just something as an AD to think about in local policy. Next one, here's another one with good conduct, or excuse me, scholarship. Student A failed a class first semester. She was not participating in basketball or bowling during the winter season. She was a basketball cheerleader, and her only sport she participates in is girls soccer in the spring. how should the violation of the scholarship rule be handled in this case as of July 1? How do you think? So her only athletic event that she participated in is girls soccer, but she's a basketball cheerleader. And she failed a class first semester. So second week of January, she finds out she has an F. She's cheering basketball and she plays soccer in the spring. How would this have been handled previously to July 1?
You would sit her out cheerleading and soccer.
The cheerleading part would be local on however you handle
Right.
cheerleading. It's not guided by girls, boys, speech, music.
Correct.
And then you would sit out girls soccer. Anybody know how the change is going to be? This is a new scholarship guidance that's going to be, and again, after July 1, so there's more to come out from the Department of Ed. Basically, it's eliminating, you want to call it double jeopardy. So how the current rule would be is student A would be ineligible for 30 consecutive days of cheerleading, but would be eligible for girls soccer. So if her 30 days fit within the rest of the girls basketball season, she could serve those 30 days with a school. If you look up there, it said a school-sponsored activity. It doesn't say school-sanctioned activity. So that includes things such as music, speech, cheerleading, dance team, FFA, a lot of areas. And so if you read that top there, this is the guide. If at the end of any grading period, a contestant is given a failing grade in a course for which credit is awarded, the contestant is ineligible to dress for and compete in the next occurring interscholastic athletic contests and competitions in which a contestant is a contestant for 30 calendar days. That's the same, unless the student has already served a period of ineligibility for 30 consecutive calendar days in another school-sponsored activity. A student shall not serve multiple periods of ineligibility because of a failing grade. Big time change. And this is something that it's taken a while to come into place. It's going to be effective as of July 1. It's going to come out guidance from the Department of Ed. They would have had guidance more out if we hadn't been dealing with this pandemic, and they're dealing with so many other things. But how that is handled, I mean, just think about it now. You know, if they're in speech, music, athletics, mock trial, I mean, it doesn't say school sanctioned, it says school sponsored. I mean, how are you going to handle clubs? How are you going to handle your organizations? How is it going to be handled, you know, with your other athletics? All right, I mean, your other activities that students are involved with. This is big change.
Gary, we already do it. I mean, I don't mean that like patting on the back. I'm saying if a kid's out, and the only thing that's tough is the clubs are kind of hard. But because it's hard to keep track of who's in what little, we have 50 different clubs, you know, but if they're in whatever it might be, robotics or the different bands, 5 or 6 different bands that we have, or if they're in all those different activities that are sanctioned by our school, and someone has an F or gets a code violation, we try to track that, and we probably have missed some before, but for the most part, we try to track it and make them accountable.
I know, but in the past, you would count each of them, wouldn't you?
Yes.
Now you can't you can't count. They're one time.
I know.
So in the past, if you'd sit them, I know a lot of them have categories. You have like music, athletics, let's say cheerleading, dance, other groups activities. And if a student would have let's say an academic, an F, they might have to sit in music. if it pertained to it. They might have to sit in speech. They might have to sit in athletics. They might have to sit in your club and groups. But the new rule says whichever one is first and they serve the 30 days, then they're done.
What if they got 3 events going at the same time? What if they're a vocal music, basketball player, and they're in jazz choir?
Whatever that 30 period, whatever occurs within that 30 days.
So they miss all that for 30 days.
Whatever's within that 30-day period.
Yeah.
But again,
What if there are none of it and they have baseball season coming up, but they go out for a club or a sanctioned activity to serve that instead of missing baseball?
Looks like they serve that in the club or whatever you're going to deem as school sponsored and what you would deem as appropriate within those 30 days.
Is there a difference between, for you, Brad, sorry, just have a question for you. So do you separate out your school sponsored and your student sponsored clubs with that? Because I could see that maybe could be your defining line with is it school sponsored or is it student led? So your student led clubs versus your school sponsored clubs.
Yeah, that's a good question. All of our clubs have to have a teacher sponsor. So if they're in a club, there's some type of club or group meeting that they wouldn't be considered sanctioned by us.
Okay.
Like what would be a student-led group that doesn't have a sponsor? What would be one? I can't think of one right now.
Well, FCA or GSA or.
Well, those all have to. I mean, for us, those all have to have a teacher sponsor.
No, I understand. All of our school or student-led clubs have to have a sponsor also. But are you saying that they could serve their ineligibility through that club, or does it have to be, music's, debate? That was my question.
Well, and again, that's where there's going to need to be more guidance out there, because if a kid's in Spanish club,
right,
what is there for that student to be, if you want to say, would lose out on? What would that student lose out on if they meet once every 3 months?
Right.
But right now it says school sponsored activity, and
so it's not even the sanctioned. It's not even our 4 associations double jeopardy. It's anything.
Well, cheerleading and dance team aren't governed by our 4 organizations either.
Okay.
And I think internally, this was discussion with the Department of Ed and their legislative group that kind of had it. Is currently it's local decision what you do beyond the 4, athletics, girls, boys, speech and music. It's dictated by the organization, sanctioning organization. But cheerleading and dance right now, that's local. I mean, some don't do anything with it, and others do. But the hard part's going to be are you going to only say competitive school sponsored?
Mm-hmm.
So you might include FFA, you might include
debate. Yeah.
Those, but not count student council, not count Spanish club, etc. So there's more to come on this. But in terms of that example of cheerleading, that would fit within the guidelines of the current July 1 rule.
So Gary, you think we should start having that discussion with our school districts on how we're going to administrate that, or should we wait for the further guidance?
What I'm gonna do is, because we have some Zoom with all of our 4 groups, I'm gonna say that at our discussion here, that was a conversation that we need to get further direction and guidance to the schools.
Okay.
But again, the key there, it says school sponsored, and again, we interpret that the same as what you do. It's not school sanctioned.
Right.
It says school sponsored. And so that is a lot broader than just the 4 organizations, and so
thank you.
Yep, we need to get more to the schools, because I agree it's a big change.
Yeah.
Well, Gary, I'll add to that. And I know I've jumped in late and I'm talking all the time now, but I've met with our district on it's really hard to balance our own handbook, because sports has a specific, like, here's what you're going to miss 30 days, or when we have code violations, we have our own policy. But when you carry those over into these unique clubs and groups, you know as well as I do, if a kid gets in trouble before they have speech, there's one contest and they don't move on to the next, and there really isn't a second chance. Or what do you do about kids in the play, and what percentage of the play do they miss? And so we've talked a lot about how to make those more equitable, just like you've heard probably many cases for 30 days in one sport is a third of the season, and 30 days in another sport, it's only 1/10 of the season. And I'm sure people have said, try to even that up, the 5 football games versus 4 baseball games, all those arguments. So anyway.
Yep. So more to come, but that's good discussion. And I think I can go back to our people to say there needs to be more direction to our schools on the new scholarship rule. Okay, here's one that came up, and student A was born in Africa. Student A's parents were both killed in warfare. Student A came to Iowa and was adopted by Family A. Family A resided in School X. Student A was placed in 3rd grade when she began attending school. When student A was in high school, the family noticed that student A's birth certificate was listed showing that student A would turn 20 years old in the summer prior to her senior year. Is student A eligible to participate as a senior? What do you think? I'll kind of move on. Iowa code doesn't allow students who are 20 years old to participate in high school athletics. So the general student, and I think many of you have done that in your spring. Sometimes when you check their age and birth dates, we've seen it before in some sports where their senior year, they only could play up to May 10th in soccer because they turned 20 and then they were done with their participation. So Iowa code doesn't allow them to 20 years old. And I said, are there any options for the family? We found that some of the foreign students, especially from Africa, many of them on their birth dates, they list January 1st. And I'm not sure that maybe they exactly know when these students were born, or at least on their birth certificate. But what we have to go with is what the birth certificate. So when it says, are there any options? I think unless that birth certificate can show that they would be under 20, they're ineligible. But there might be some way of going back and investigating and trying to find out exactly when that child was born. So we ran into that. That's a true one that happened this year. A student from Africa, and they turned 20 and they didn't really know if they were 20 or not. And so you had to go with what was on the birth certificate. And so there are other options would be to, potentially see if the birth certificate was wrong. This is kind of the final little keynote. And these are some things I know a lot of question comes in is, how do we know for sure if a student is truly a resident of our district? And sometimes being in the city area around here, there's a lot more mobility to move and be around people. So the bottom line is, don't let a student participate solely because she lists an address in your district. Verify the information to ensure the student and her parents, or custodial parent in the case of split family, have indeed completed a bona fide change in residence into your district before she's allowed to participate. We've had some situations where, and here's where you can imagine where it happens is, other parents in the district call the girls' union or boys' association and say, Mary doesn't live there. They're just saying they live there, but they really live elsewhere. We've got pictures showing them that's where they live. The neighbors all say they live there all the time. So don't just rely on an address. Some things to consider. And then this is his next part. voter registration, driver's license, homestead tax credit, nature of property rights in the district, lease versus ownership, long-term lease or month-to-month, removal of all personal property to the new residence. Is the student and her entire family physically present in the district for the purpose of making a home? People are allowed one resident. You have one resident that is your resident of where you live. You can't have, for the purpose of making a home, yes, you can have a lake house, you can have another home, but for the purpose of making a home, Iowa code defines that as you can only be in one residence. And so the suggestion is on that transfer checklist, do your homework, get all the information that you can to ensure, because there are people out there that are watching and checking. We had a situation this year where a kid was playing one sport and a bunch of the community people said, this is not the case. They are not there. Gene did a home visit and found out they were living in a different district and they were ineligible, and there were some forfeitures that occurred. So
Good for her. Good for her to follow up.
So anyway, if you do have situations, and again, you want to trust in everything, but get your part in place so that if we ever get called and we go to you and say, hey, can you, we got somebody questioning the residents, they're wanting us to investigate it, we would go to you and just say, hey, get your transfer checklist. These are the documents if you can provide. I had that happen it was a girls basketball player, and the school provided all the information, and it was the resident where they were supposed to be, but there are people out there questioning it. So, and it usually doesn't come from other districts, it comes from your own districts. People are watchdogs. Questions about anything? I know I went through a lot. I probably went longer than what I needed to Scott, but these were some situations that I have actually had calls on and had to deal with, and I thought it'd be kind of an interesting session just to kind of talk about eligibility 101. And some of these are, again, rural class 1A schools. Some of these are suburban 5A schools, so it can happen anywhere where you have these types of transfer and open enrollment and situations.
Thank you, Gary.
Gary, did you talk anything about COVID-19? I got in late, about grades this semester, no pass or potentially no grade, like if a kid's given a no mark, for example, because the school didn't have a chance to finish. How are we handling this second semester of this 2020 year?
Yeah, we had got to get, the boys and the girls had got together with a list of, I bet there's 10 questions that we submitted to Department of Education. We gave our recommendations on how we would like it to be handled. We have conversation from them on what it's going to be. It's right now waiting for the governor to give stamp of approval. Once she gives the approval, then we'll do a Q&A related to all ask. I mean, here's some examples of it. Physicals. What about physicals? The kid is going to play softball or baseball, and they can't get into the doctor's office. Their physical expired in the middle of May. How are we going to handle it? So we had asked for a waiver, guidance from them on how we could communicate with them. On scholarship rule, how are we going to handle grades, for second semester? How's it going to be pertained for softball, baseball in the fall? Transfers, open enrollment, how are we going to count the 90 days if they're in a transfer mode based on all these things? Open contact rule. This is the other part that people don't realize is the contact rule is Iowa code from June 1 until the start of the fall practices. And so basically we're getting guidance from them on how are we going to handle the contact rule? Is it going to be moved back to June 15th? Is it not going to be allowed? What is it going to be regarding that? Let me think of what some other ones. I mean, and so what
I appreciate your guidance on that. I got in here late, but I was wondering about those related to COVID. So if something's coming out, I really appreciate you guys, what you're doing.
It's waiting right now, probably for the governor, but I know the governor's gotten like 500 waivers. You know, example, nurse can't get a recertification because of not taking the classes. Can she continue to serve as a nurse? I mean, those are examples that she's getting a lot of those kinds. And so she probably isn't viewing this as right now, but she'll take care of it and get it to us. And then we'll get very quickly. Tom Keating just emailed yesterday. He had gotten guidance from the Department of Ed responding to our suggestions. And so we're kind of right now getting the wording all in the event that the governor signs her stamp, then we're ready to come out with that. It's a unique year, guys. I mean, it's just kind of, we don't know, you know, and I know we get a lot of questions. What about softball, baseball? What can we do with our if I'm a volleyball coach, what can I do now in terms of virtual communication? And what about in the summer? What can I do? Softball, baseball, what can we do?